Well, hello again, everyone. It's Rob Ryder on Sunday, February 18th, 2024. And today, Deceptive Practices, Part 2B, actually, Real Estate Ripoff. I say that because I did a lot of what I'm going to tell you today. I did in a video last week, which was called Real Estate Ripoff by Deceptive Practices, which you can see was removed by YouTube because I violated their terms and policies. So I'll try to do a better job this time and keep YouTube happy and at the same time get the information out that I wanted to convey, which is basically that if you've been involved in a real estate transaction, well, you've been ripped off. It's called a deceptive practice. And because it's a deceptive practice, you could either try to take them to your state's attorney general under your state's Consumer Protection Act, which is where they talk about deceptive practices. But if you read those acts close enough, it says that you can also start your own action. And so that's what we're going to do. And what we're going to base it on, we'll try it here with an example, is to go for the escrow or the earnest money that you put up to make it a small claim. The idea being that if you go to court for a small claim and it's a deceptive practice and the judge finds in your favor that he's or she has agreed that the other party has committed a crime, because a deceptive practice is a misdemeanor. Or it could be a felony. It's either or in Illinois. So, I say, well, they can't go to court because if they get a judgment against them, they're going to go to jail. So it would force them to mediate ahead of time. And as it turns out, mediation is part of small claims courts. At least in a couple I looked at, it talked specifically about mediation. So, so that's the idea. Find something in these documents that you have for the purchase that you made in your property. Call it what it is, a deceptive practice. Go file a small claim against the deceptive practicer and see if you can get a judgment in your favor, or better yet, never even have to go to court. But just get the party to agree with you. They need to settle out of court. Whether that taps their insurance or not is, that's not our problem. That's their problem. So let's get on with it. And I am Staff Sergeant Robert Allen Retluski, U.S. Army veteran, also known as Rob Ryder. My email address is courtofrecord@aol.com, and you will find my videos on Rob Ryder on YouTube with ROBBB, 3 B's, ROBBBRYDER. Okay, so give me a minute. We'll get started here. Hang on a second. Alrighty. So you could say that, the beginning part of purchasing your property ends here with this thing called a closing disclosure, which I don't know exactly when you get this, if it's at the closing table or how much sooner, but basically it tells you who's involved in the transaction. Right? You got a settlement agent, you got a borrower, you got a seller, you got a lender. Well, and each of these people have some kind of file or documentation that have something to do with your case, and so with your purchase. So you have a right to look at it. So like the settlement agent, which is in this case the title company, they have a file number, right? So if you contact the title company and say, hey, I want a copy of that file number, the information in the file number, then they should have to give it to you because it's your transaction. The same with the lender, right? They have a loan ID. And because this was FHA, and they also have this other ID number, so, well, if you want to know what's in your loan package, well, get a hold of your lender and tell them I want everything in loan ID, blah, blah, blah. And they should have to give it to you. All right, and so that's how you get the information for what I'm going to be showing you here in the video. This is the starting point. Now, if you have a really old mortgage, then I don't know that they're still going to have this, because sometimes there's things about having to keep the information for 7 years and so forth and so on. And, but I'm not going to worry about that. Now I'm going to do an easy one. I'm going to do a foreclosure, or not even a foreclosure, just a sale in the last year, where Kimberly, the purchaser, early on knew that something was up, and she had been watching videos anyways, and that's how come she got a hold of me, because of some of the things I said in my video about the title insurance and so forth. So, yeah, we're going to use hers as our example, because she has all the information available, and well, let's see what we find out. So, this is like a 5-page form, and there's not a lot in between the pages that have anything to do with us. It's more about the particular transaction. But when you get down to the last page, or the second to last page, you got contact information. For the lender, if there's a mortgage broker, your broker as the buyer, real estate broker, if there's a broker for the seller, and the settlement agent. All of them have something to do with this transaction, but they don't all have the same thing to do with the transaction. So really there's like, let's say there's 3 legs on this stool. You got the lender for the money, you got the brokers for the land, and you got the settlement agent supposed to be putting the finishing touches to all the pieces. And in this video, we're going to be mainly focusing on the broker information, because that's who you actually have a signed contract with, where you signed it on one side, they signed it on the other. These other people, they're just involved because somebody somehow got them involved. But you never signed a contract with the lender, so there's no way they could have lent you any money. And you didn't sign a contract with the settlement agent. However, your broker, acting as you, may have signed something with the settlement agent. But that's what the broker is supposed to do, is act as you, or for you, I won't say as you, for you, in this transaction, because they're the ones with license to transfer title. Right? We can't do it ourselves. It has to be, have to have license. And so for all these different, functions, everybody has to have a license. And this NMLS is a national licensing repository, where in this case, you got Texas licenses. Well, these people are licensed by the state also. Right? So now you can get certificates that prove that, who has a license, who doesn't have a license, what their license is for, were they using their license for the right thing in the right position for what they were doing, and yada, yada, yada. So, for instance, let's just look at this NMLS real quick, which this is their NMLS ID, and this Texas license is their Texas license ID. So, 2973. So, if you go to NMLS, just Google it, you'll find you can get this access here. And 2973, we're going to put that in and hit enter. And you got to do a little thing here so they know that you're, not a computer. SH4H. 4H. Well, under that number, you got a whole bunch of people. There's 106 people that are living off of that number. But the one we're interested in is the Wallace and Volk Incorporated, because they're the ones who claim to be the lender. So you click on that, and you come to this page here. It's kind of hard to read, so I'm not even going to try. But it has their address at the top, and blah, blah. Then you get down to regulatory actions, none posted. Then you come down here, and you see all these different places that this place is licensed. And we're talking about Texas. Now, if you click on this one here, this is Texas SML, this will take you to the Texas Licensing Board that gave these people a license, apparently to be a mortgage banker registration. And then you can submit a complaint to the regulator, which we may do. We weren't doing that first, but we might get around to that. It's just so much to do. But then you have this one here, view details. So let's take a look at the details. And you come down here and you see that view license status history. It says for started that and it ends present. So it sounds like, well, okay, they no longer have a license. It's ended. It's present. I don't know what that means exactly. They have to explain that to us. But then they have this next one, view resident registered agents for service of process. And this says then that the registered agent is actually at the company, right? This Julie somebody, branch manager, someplace in Texas. So she's supposed to be the registered agent. Now, I believe if you go online on the state, like the Secretary of State website, we look for companies that have been properly either formed in the state or they're foreign corporations that are recognized by the state. You know, every corporation is supposed to be, I don't want to really call it a license, but registered with the state. So, and they had a different company listed, if I'm not mistaken. But I looked at so many papers, I don't know. But I'm just showing you, this is what it says. So, you know, this is who you might, if you were going to sue these people on small claims, this isn't who we're going after right now, because we're going after you don't really have a contract to these people, right? This is the thing. But I'm just showing you that when you go up here and look, it says regulator, Texas, something or other, license / registration number, none. Right? These people aren't licensed or registered in the state, according to this. Right? So there's no way they could have lent you any money. So that's just an example of what this is for. You know, that the people that you're going to find on here, on this website, are the ones that are you know, whoever has an NMLS number is going to be on there and there. Now, if they're a lender, their Texas ID number will get you to them also, but not so much with the real estate broker. This licensing is done through a different agency. So it's the Texas Real Estate Commission, right? Certificate of License History, where this is the name of a company that has a license as a real estate LLC, license number, so forth and so on. Where this is one for a person, right, who's a sales agent, active, Well, both of those numbers, you know, show up somewhere in these numbers here. All right, so either it was this 663-685 or 9003138, but they're on there. So, you know, after you ask them for all the information, like, you know, contacting the people on the first page. Oh, come on. All right, and I say I want the file number, university title, I want the file number, lender, I want the loan ID information and this MIC information. It's time to go to work. All right, so then while you're waiting for that, come down here and start finding the licenses. And again, we're looking for stuff to do with the broker, buyer's broker, because that's who you have a contract with. But as we continue on in this document, the applicant never signed it. So, by signing, you are only confirming that you have received this form. She didn't sign it, so she never received it. That's the way we're going to play. And addendum to closing disclosure, right? They say that this is the property. And it gives the name of a street and unit A and B, Houston, Texas, with this. Well, as you're going to see, this isn't the same address that's on the contract that you signed. It has nothing to do with it. I mean, the zip code's different, and there's no unit A and B in the street description. In fact, we're going to look at that right now. So, right from the beginning, even this is wrong. Or it has wrong information. That helps you in your case to say, well, what I bought is not what you're charged me for, so I'm not going to pay you anymore. Right? I didn't buy this thing, unit A, B, Houston, Texas, 77016. They bought something different. Okay, so let's go now and look at what we're doing in this case is we filed a small claim, and I'll talk about that in the next video. It's just too much to try to put in one video. But we filed a small claim against the broker. So let's see why we did that. Because at the very beginning, when you go to buy property, now this isn't the same for everybody, obviously, but if you go to the local real estate agent and say, hey, I want to buy a house, right? This is more along the lines of what you would be doing. Where the first thing they're going to have you do is sign some kind of representation agreement. And I want you to notice they didn't use Kimberly's full legal name. It was just her first part of her first name and her last name. Again, I say you don't have a middle name, so you cannot have a middle initial. Right? Robert Allen is my first name. So you can't say my middle name is Allen and then give me an A for middle initial. That's not who I am. I'm Robert Allen, first name Rutluski. But that's what they did for Kim. And then they didn't give her an address, like she's homeless. Right? They have phone and a fax, and then they have their information. And then appointment, client grants broker exclusive right to act as client real estate agent. Well, that's pretty clear. For the purpose of acquiring property in the market area. Check. Well, what does that mean? Acquire means to lease, to purchase or lease. And closing in a sales transaction means the date legal title to a property is conveyed to a purchaser of the property under a contract to buy. So right? Did they transfer the frickin' title? Until the title's been transferred, the closing has not happened. And property means any interest in real estate, including but not limited to properties listed in a multiple listing service, so forth, so on. Okay. And what the obligations are: to assist client acquiring the property, assist client negotiating the acquisition. You got some obligations as the client, exclusively represent the client for purpose of acquiring property, right? You're not going to use a different broker, just this one broker. And then each of these pages then, because this is a secure form, I had to print the form and then highlight it afterwards. This would normally have like the blue border around it, like it was a secured form where you can't change the information inside of it. Okay, and then you'll see that it says buyer-tenant representation agreement between Kimberly and Anna, somebody of real broker, something or other. So, that ties every page has it on there. So I hadn't noticed before that this line was on there until yesterday when I was highlighting these for this video to cover up as much as I thought I needed to get it to go through. Right, so there's this other player involved, which is Anna. And Anna is, she's in here. Oh, I went the wrong way. I think that she's right in here. This contact, right? This is her. I can't show it because, I'm trying not to show anybody's information. But she's listed in the contract information. Okay, but she's saying that she has the authority to do it for the broker, so be it. Each person signing this agreement represents that person has legal capacity and authority to bind the respective party to this agreement. So if Anna didn't have the power to commit real broker to a contract, then Anna committed the misdemeanor. If she did, well, then real broker committed the misdemeanor. Right? But somebody's committed a misdemeanor. Broker's not authorized to execute any document in the name or on behalf of the client concerning the property. Okay? And then they're going to act as an intermediary, right? Client desires to see broker's listings. If client wishes to acquire one of the broker's listings, client authorizes broker to act as an intermediary. Well, I don't know if there's a legal definition for intermediary, but, that's like the person, your agent going and putting the deal together. Competing clients, they're going to get paid a commission, where the commission's coming from. Broker will seek to obtain payment specified in 11A from the seller, landlord, or his agents. And if they don't pay, well, they're going to come after you. Earned and payable. A person is not obligated to pay the broker a commission until such time as broker's commission is earned and payable. Broker's commission is earned when client enters into a contract to buy or lease property in a market area, which is the next form we'll look at, or the client breaches the agreement, or broker's commission is payable either during or separately. Now, broker's commission is payable either during the term of this agreement or after it ends upon earlier of the closing of the transaction to acquire the property, the client's breach of the contract, the client's breach of this agreement. So, knowing that, well, where are we today? Well, Kimberly is living in the house, and the broker says he's been paid. He or she, right? Because he called and said, hey, did you get paid your commission? And they said yes. And we don't have a receipt for it. We're just going based on what they said, right? So, you said you got paid. Well, if you got paid, and it's payable upon the closing of the transaction to acquire property, and we've looked at the definition of what closing is, which means the legal title of the property is conveyed to a purchaser, then where is her legal title? Now, they're going to want to tell you, well, that's what the warranty deed is, and the deed of trust. But no, it has nothing to do with it. The deed of trust has to do with the financing. It doesn't have to do with the legal title of the property. And a warranty deed is not legal title. Especially when we take a look at what's on it. You know, it's like, duh. It's terrible what they do. Let's see if there's anything else we had to see here. Client authorizes a broker may so instruct an escrow or closing agent authorized to close transaction for the acquisition of property contemplated by this agreement to collect and disperse broker all amounts payable to the broker. Okay. So this escrow authorization, this is where that universal title comes in. They're wearing like three hats in this deal. Settlement agent, escrow agent, and another one. Mediation, the parties agree to negotiate in good faith an effort to resolve a dispute that may arise related to the agreement or any transaction related to or contemplated in this agreement. Well, that's what we're going to try to do. We're going to take it to small claims court and let them mediate ahead of time or go to small claims court to try to get a conviction for a deceptive practice because there is no title. We're going to show you what it looks like. So we're, until you give me this paperwork, I don't have a title. And that was what they're supposed to do. They're the ones with license to do it. And, signed by both parties. So it's kind of hard to get around. Okay, so from that then, okay, this is the first piece of paper. Now they can represent you. Now they let you look at their list. And eventually you find something you might want to buy, and it shows up on a document like this where some seller is a party, is going to sell it to some buyer, who's the other party, to convey to the buyer, and buyer agrees to buy from a seller the property defined below. Then it gives this property description. All right, Lot 1, Block 1, Blank Estates Edition, City of Houston, County of Harris, Texas, known as, and then this has got the street address on it, and then it has a zip code, 77028. Now, it doesn't say it's a zip code, right? But that is a zip code. But what's missing in between is, there's no city or state. It's just, so this is like a commonly known as. This isn't necessarily a legal thing they put on here, but for whatever reason, they've decided to leave Houston and Texas off of here. But continue on, or as described on an attached exhibit. Well, there's nothing attached to this document, so I'm going to say there is no exhibit. That'd be something they'd have to bring to court to prove, right? We're just going based on what they gave us. And how did we get these? Well, Kimberly contacted the frickin' broker company and said, hey, I want a copy of the documents that we signed for the purchase of this property. And because hers was like last year, they still had all this stuff. But like after 7 years, they may not have this anymore. But I've noticed that all this stuff seems to be in this DocuSign envelope, right? Not just this information, but other information. So maybe that DocuSign envelope has all the information in it, but doesn't really say where to get it from. Someplace there's an envelope, lots of information. Reservations. Any reservation for oil, gas, or other minerals, water, timber, or other interests is made in accordance with the attached addendum. Well, there's nothing been attached about that, so apparently there's no reservation for the oil, gas, or other minerals, water, timber. It's all yours. Right? That's the way you were buying it. You were buying it fee simple with all rights. And then we come down here and we see that there's going to be some earnest money that's going to go to the title company, who's going to be the escrow agent, right? $3,700 and $140 for option fee. So that's the money we're going after, right? This earnest money. So money you had to put up front to get the deal going. But that money was going to your broker, who was supposed to get these people involved, right? The broker, if you remember from the other page, we're doing the deal with the closing agent. Right? Escrow authorization. Client authorizes and broker may so instruct any escrow or closing agent authorized to close the transaction for the acquisition of property contemplated by this agreement to collect and disperse to broker all amounts payable to the broker. So they're the ones who got the, escrow agent involved. You don't have a contract with them. So it's kind of hard for you to go against the escrow agent. You don't have a contract with them. The only people you have a contract with is the broker. And now we're looking at the seller you have a contract with because you're buying their property. Title policy and survey. Seller shall furnish to buyer at seller's expense an owner policy of insurance, the policy issued by Universal Title Company. Which is kind of not true. They're acting like as the agent for the insurance company. The Universal Title Company is not the frickin' insurance company. It's actually being insured by somebody else, and Universal Title is acting as their agent. But nevertheless, that's what it said. Then it says a commitment within 20 days after the title company receives a copy of this contract. Seller shall furnish the buyer a commitment for the title insurance. We're going to look at that in a minute and see that they sent something, but none of it was signed, so there really wasn't a commitment sent. But again, Kimberly contacted Universal Title and said, hey, where's the commitment that you were supposed to send me? Oh, we sent that to you in an email, right? So they resent it to her, and sure enough, they sent her something, but it's not been signed by anybody. But what were they supposed to do? Within 20 days, right, had to provide the buyer a commitment for title insurance. If the commitment and exception, and at buyer's expense, legible copies of restricted covenants and documents evidencing exceptions in the commitment, exception documents other than the standard printed exceptions. Okay, so I want all that stuff. Where's all that information? Whatever that sentence is supposed to mean is exactly what I want. Seller authorizes title company to deliver the commitment and exception documents to buyer at buyer's address shown in paragraph 21. Well, guess what we're going to find in paragraph 21? We're going to find there's no address. Jeepers. Sounds deceptive as hell to me. If the commitment and exception documents are not delivered within the time required, buyer may terminate this contract and the earnest money will be refunded to the buyer. Well, then give me back the money because it never happened. That's what we're saying. Survey. A survey must be made by registered professional land surveyor acceptable to title company and buyer's lenders. Check number 2, within 15 days after the effective date of this contract, buyer shall obtain a new survey at buyer's expense. Buyer is deemed to receive the survey on the date of actual receipt or the date specified in this paragraph, whichever is earlier. So I'm putting this on the broker because they're supposed to be acting as the buyer's agent. They should have got this shit done, not Kimberly, the broker. So where's the survey? And, well, as it turns out, there is a survey, but I have to look at that some other time. Adjectives. Buyer may object in writing to defects, exceptions, or encumbrances to the title disclosed on the survey, other than items 6A through whatever. So basically, right, you had to have the survey to be able to determine what kind of encumbrances there were. Right? It has nothing to do with that deed of trust or warranty deed, the survey. Because the survey is really your title. When you have a survey that has your property on it, we'll see an example of one, and it says to the side who the owner is and it has your name on it, well, then you're the owner because that's been filed with the county and everybody agrees. It's like your treasure map, right? That's yours. Everything in that box is yours. And now, if you were to have a trial by record, the record would be in your favor. But if you had a trial by record today, you would lose because the record in the frickin' the county doesn't match what you're telling them is yours. And each of these pages, again, 77028, right? That's the address that your zip code of the place you're agreeing to buy. And you can see they put Houston, Texas in here now. Wasn't in there at the beginning. Well, they put it in now. So be it. Title notices, abstract or title notice. Broker advises buyer to have an abstract of title covering the property examined by an attorney. A buyer selection or buyer should be furnished with the obtained title policy. If the title policy is furnished, the commitment should be properly reviewed by an attorney of the buyer's choice due to the time limitations of the buyer right to object. So you could have asked for an abstract. Okay, well, that's what, okay, I want the title policy and I want an abstract. I want an abstract of title. Or we're not closing. Well, they probably wouldn't close, so, there you be. You got these taxing districts and so forth. Seller to deliver to buyer to sign the statutory notice relating to tax rate, bonded indebtedness. Did it happen? Who really knows? Broker's fees. All obligations of parties to this payment of broker's fees are contained in a separate document. Well, we saw what that was, right? And this is the date that it was supposed to close. So on January 31st, 2023 is the date that legal title should have been conveyed to the buyer. But instead, she got possession, right? Which is part of legal. If you had fee simple, you would have possession. But when you only have possession, possession is 9/10 of the law, and the other 10th is the legal title. You don't have that just because you have possession. You have equitable title. You have the right to use it and to dispose of it. But, you're a tenant. You don't have the title to the property. Settlement and other expenses. We got some more money we got to worry about. And, well, that isn't what you paid out yet. Escrow. The escrow agent is not a party to the contract, right? So you really can't go after them. They're not a party to the contract. There's other reasons to go after them, but they're not a party to the contract. Upon termination of this contract, either party or the escrow agent may send a release of earnest money to each party, and the party shall execute counterparts of the release and deliver same to the escrow. Now, escrow is different than earnest money, right? Escrow is like you put your money for taxes and so forth and so on. And to be honest with you, every payment that you ever make on a house payment is going into some kind of escrow account. What they did with Kimberly, and I'm sure they do this to everybody, is that on her note that she had, it gave an address to send the check to, right? Name of the lender and an address. Well, she sent 2 checks there, and then she got a mail that said, well, now send your payments here. And they gave her someplace else to send them that had a different name of a bank and a different address. Well, the note says you can change the address, but it doesn't say you can change the name of who you're sending it to, which is exactly what they did. Again, though, that's the lender. We're not going after the lender today, but I'm just saying that's the money transaction, which is separate from the real estate title transaction, which is all we're worried about here, is the real estate title. Forget if there's a loan. Forget if they say you owe money. Forget. Just remember what it said, that closing is when they transfer you legal title. Until they transfer you legal title, there has not been a closing, so you don't have to pay anybody. Damages, any willfully refuses to sign or release sectable to disgrace in 7 days. Okay. Representation, agreements of the parties. No. Now, executed the blank day of. So they have this a particular way they want it filled out. Instead, somebody put in 12/31/2022, which is not how they wanted it. They wanted the date first, which would be the 31st day of December, 2022. Right? The broker is supposed to fill in the date of final acceptance. So there's never been any final acceptance because they didn't put the date in right. It doesn't start with 12, which is the month in this format, right? 12/31/2022. 12 is the month. Well, they wanted the day first. And this is this trick is as old as can be, because like in England, they have the month and the day switched around in their date showing like this, where it's, they'd have 31/12/2022 for the 31st day of December. We have December 31st, 2022. So when you're using this format, unless it's specified, that's what they want, then this is really meaningless to this contract. What it is a deceptive practice. And the buyer and the seller signed it, so, again, this is a contract. And then it gives the broker's information, right? Buyer only as buyer's agent, right? Represents buyer only as buyer's agent. That's pretty clear. You're my agent. You're responsible for this, and here's the people responsible. And then the seller had his agent, did the same thing. And then this is done, right? There's no addendum attached. There's no other legal description attached. There's nothing else attached. This is all they're giving us. And while it's not on this page here, Kimberly had another page where it showed that these option fee and this receipt had both been sent. And in fact, where it said earnest money, there was a stamp on it from Universal Title showing that they had gotten it. So they got paid the $3,700 and $140 other dollars. Right? Money's been paid. Didn't get the title? Well, go sue in small claims against your broker for not getting you the title to this property. Because again, they told Kimberly they've already been paid their 3% commission. Well, she didn't get the title. Well, alrighty then. Let's take a quick look at the commitment that Universal Title says that they sent to the buyer. Which, hang on, I want to show one other thing. I guess I didn't cover that too well. Go back here. Execute contract. Did I show block 21 where, right, block 21, right, it has no address. This is where they're supposed to send any notices or anything, right? Well, there's no address to send anything to. And email is not the same as sending it by mail or some other way, or by fax even, right? Email isn't part of the common carrier system. So I don't know that you can use it in law to say, well, you did something, because it's not considered a qualified way to send stuff that the government recognizes. Right? They, it's not like registered mail or certified mail or sending something by fax. All those are part of the common carrier system. But email has not been made part of that. So, right, this is what they were supposed to send, and what we're going to look at. And this is, when she asks again, this is what they sent her. And the very first line, right, in bold says the following commitment for title insurance is not valid unless your name and the policy amount are shown in Schedule A. And our authorized representative has countersigned below. Right? It's going to be issued by National Investors Title Insurance Company. So this is really the insurance company, not Universal Title. They're just acting as their agent, the authorized representative. Now, whether they are or not, I don't know, because they didn't sign. So you don't have to go any further. You say, well, you didn't send me anything. This has not been done right. Right? I don't have a commitment. Well, that's fine. We'll go a little bit further, and we'll see that, right? Another place for a signature. Nobody signed it. And then we go into Title A, which is supposed to have like all the information for the buyer on there. And again, on the contracts with the broker, it's just Kimberly last name. But on here, it's Kimberly middle initial last name. So they're insuring not the name that's on the title paperwork. I mean, on the buyer's paperwork. Well, it only gets worse. Because then they sent this final to do with the final title insurance information, right? Where it's Kimberly R. And then I closed it now. Shoot. Let me open it up. So you see this settlement agent, right? So escrow agent, settlement agent, closing agent. All these people seem to be the same person, this universal title. That they had a file number. Well, that file number is the same as this C23 number. But here they put this GFNO, which is not on, right? There's no GF on this. It's just the numbers. Which makes me think that this here is like a general file number or something. Like maybe this university title company has their own book in the records of the county, and it's been put in those books, but not necessarily in the official books. I don't know. I just know that, well, what's GF mean? We're going to have to find it out this week, because that isn't, GFNO is not on the record that you would get. You just give them this number here, C235, blah, 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 blah. Okay, then we got owner's title policy number, and then contains some stuff, and also includes a copy of warranty deed recorded under this document number and the official records. So the warranty deed has been copied in the official records. But where has this been copied? What's this GF stuff? I don't know. It's recommended that you contact taxing authority to change the tax records in order for this property to be assessed in your name. Well, go figure. As well as receive any tax exemptions to which you may be entitled. I don't think that happened. All right, and there's that file number again, Schedule A, and so forth and so on. And so when we look here, right, now the name of the insured is Kimberly R. And this is the legal description. Lot 1, Block 1 of some estates, a subdivision of Harris County, Texas, according to a map thereof, recorded in here on this film code number of the map records of Harris County, Texas. Well, that isn't what she agreed to buy. She agreed to buy Lot 1, Block 1 of some estates in the city of Houston, county of Harris, Texas. Commonly known as with some zip code. All right, well, this isn't the same. Subdivision of Harris County, Texas. Where's the city of Houston? Right, so they're, giving you, acting like they're giving you insurance on something that you didn't buy. The other thing is, right, that this is the, like the address of what she was supposed to have bought, but they've changed the zip code. Now it's 77016. Well, all right, that's not the same as 77028. They changed the frickin' zip code. And then we go down here a little further, and we see that they're going to do Kimberly R. I already showed this part, okay. So that's all been taken care of. Now they have this with the hyperlink that you can link it. So let's just go ahead and do it since we're here. Hopefully it doesn't take too long to show up. And as you see, it's not taking you to the county website. It's taking you to the university titles website. Well, why is that, right? I thought we were going to look at... hang on here. Let's get rid of that. All right, Lot 1, Block 1, Blank Estate, Subdivision, Harris County, Texas, according to the map thereof, recorded in, film code, number, something of map records of Harris County, Texas. But when you hit this, it doesn't take you to the map records of Harris County, Texas. It takes you to the records of University Title Company. And as you'll see, we got this map, survey, where we got this box here, and it's got an arrow going in, pointing to it, and it's got a circle here that says what it says, which is basically that this has been recorded. Right? That's the recording staff for the county. And then over here, as we'll see, it's got this little block here that says name of the owner, and it gives the name of the owner. But it's not Kimberly's name. So since we're really not talking about the property that Kimberly bought, but this property that has this other zip code, 77016, and has a different legal description than what was on the agreement, I think we could agree that she hadn't bought it. And then all these exceptions then go to the property for 77016, not the property for 77028, which is the property that Kimberly bought. But nevertheless, these are the exemptions that were talked about when we were looking at the broker information report. Talked about exemptions and getting the commitment and some of these other things, right? So it would be good to have gone and looked at all of these to see what they are. I mean, I haven't done that yet, but again, that's because there's no proof that the legal title has been changed. That map is part of the legal title, and that map doesn't have her name on it, so it's not her map, so it's not legal title for her. But it has all these other things that were happening that would be good to have looked at. But you can see they changed it now, right? Now we're talking about Kimberly R., last name, and unmarried woman. She's the grantee, right? They made this legal fiction out of a legal fiction. They just keep expanding it, but it's never the person in their full legal name. So it doesn't really apply to you. But you do get rights in party of possession, so that's 9/10 of the law, but not the last 10th. And that lists all these different places where you're going to find something that had something to do with the property that either you bought or the one that they're trying to make you believe that you bought. But the one that you bought is this one here, and this ain't the one that's on the paperwork. You don't have a commitment for it, and all sorts of things happen. And, well, your closing agent or your buyer's agent, buyer's broker's already been paid, so where's the agreed upon documentation that meets the criteria of closing, which is in a sales transaction means the date legal title to a property is conveyed to a purchaser. Didn't happen. Okay, so this is that map we were looking at a little bit earlier. Map, it's a survey. Right? It's been boxed in. It's like, okay, here's block 1, block 2. Block 1's got 2 lots in it. It's on some street. Got an arrow pointing to it for lot 1. Then there's lot 2 over here. And it's been, blessed off by every office in the jurisdictions. This says where it's been recorded, and that number's, doesn't matter how much I enlarge it, it's hard to read. But then it says over here, right, the owner. which is blank investments, which is the place that she bought it from. Right? Lots 2, block 1, prepared by. So this really isn't hers. I mean, because there are actually 2 lots, and she's only bought the 1 lot. Lot 1, block 1. Right? So she bought this one here that's pointing to, but there's actually 2 lots in there. So this is not, quite hers yet. And with this, though, was this other page. Now, again, I'm just looking at, if you went to the link on the title insurance, these are the 2 different pages that were on there. But I had to conceal some information to, keep YouTube happy. We'll see that you get a tax certificate from the Harris County Tax Assessor's Office that gives a legal description. Now, this isn't the legal description of Kimberly's property, but it's not the same parcel address. It's the one next door, 8705. Hers is like 8715. So this is the other lot, not her lot. Who it was issued to, and who the certified owner is. Right? So, and it costs $10. Well, there's a $10 certificate fee. If you ever look at a deed, it usually says for $10 a hand paid and other valuable consideration, We have to have $10 for the certificate. So until you have a map with your name on it and a tax certificate with your name on it that has your legal description and your parcel address on it, well, you're not the owner, right? This is the legal title. It's not the frickin' warranty deed. This is. And Kimberly doesn't have one. So whose fault is that? Well, that's the broker's fault. This is what he was supposed to get you. I want this. I want my frickin' survey map got my name on it. So you have a certain kind of survey called the cadastral, C-A-D-A-S-T-R-A-L, cadastral survey. And a cadastral survey uses this public land survey system to do the survey. And a public land survey system is the survey system that the United States used to survey all of the townships, districts, call them what you will, it just depends on where you are in the United States. And then that's how they gave it to the state. So if the state was going to give to you what the United States gave to them, they'd have to use the public land survey system and give you a cadastral survey, because the United States, the Bureau of Land Management says that legal title to land as far as the BLM is concerned is a cadastral survey. And a cadastral survey, other than having normal survey stuff, also has the owner's name on it. It says owner. It has a name. Well, if that's owner is you, then you're the owner. And you don't have one of these. Okay, so remembering all the time what it is you bought, which is Lot 1, Block 1, Blank Estates, Addition, City of Houston, County of Harris, known as something or other with a zip code. Well, if we go and look at what the warranty deed says, right now, so here's that universal title GF number with this C2355001CY. That's the packet of information that was on the first page of the settlement statement, but they added this GF in front of it, the universal title, and that's where it was recorded at. Well, where the hell is that at? Well, it doesn't matter. So here we go. General warranty deed, bunch of stuff, but it says 8715 Unit A, Unit B, Houston, Texas 77016. Well, none of that's on here. There's no 77016 anywhere on this document. Every page you look at talks about it being Houston, Texas 77028. right? Sum of $10 and other good and valuable consideration in hand paid by. So they're saying they've been paid, right? But it has the wrong information for the legal description. It's not 77016. That may be the mailing address, but it's not the residence address. And so I think that's the thing. I should stop here real quick. I believe this is your residence address. So like if you were going to go and get your driver's license or state ID, and they have one spot where they want to have your residence address, another spot if your mailing address is different, then to put it down. And this is how they made the difference, right? Where this, road, whatever, Houston, Texas 77028, well, that's your residence address. But your mailing address is the same thing, but 77026 or 16, whatever they had in this final policy someplace. We'll take a look at it again. And then this has this legal description here, which, this isn't what she bought. This is there's nowhere on here it says it's in the city of Houston. It's the same thing that they used before. Well, this is not what you bought, so I don't know why you're paying any money on it. All right, that's the warranty deed, and that's almost as bad as the thing that they're trying to pass off as a deed of trust, which has got that same universal title number on there again. It's a deed of trust, got the min, the mirrors, where it says the borrower is, somebody, middle initial, unmarried woman. That's not her name. And it goes on in here to say that, that this is the legal description, which is not the legal description on the document you have with the broker that says that you're buying it. So this isn't what you bought. So, it's a deceptive practice. So again, these are for the money side of things. And for now, we weren't going after the money side. We're just going after the title side, right? To split them in half and say, well, we can find what we need for, what they're supposed to do to close. So now we know what it looks like and what their obligation was to get paid, which was, down here, earned and payable. It's not payable until either the term of the agreement or after it ends or earlier of closing of the transaction to acquire the property. Okay, well, where is it? What's closing? The date means the date, legal title of the property is conveyed. Until it's been conveyed, there's been no date. It's supposed to have been done by the 31st of January or 31st of December 2022, I think it was. It never happened. So, so we have filed a small claim for the 3840, I guess it is, against the broker, using the broker's name because they have a license, and finding that that broker with that license had a registered agent, and sending it to the registered agent, care of the registered agent. And that happened last week, and when Kimberly took it down, they said, well, it takes 4 to 16 weeks for this to get served. So anyways, we got time to work on that later in another video, but I wanted to get this part done again because it's really important that this is what's happening, right? When you started, this is the very first contract you got involved in, and it was with the broker. And for the very first line, they started to lie, right? They didn't put her full legal name, and they didn't give her an address. And that was just lie built on lie built on lie, which is a deceptive practice, so take them to court. If you can get them served, right, if all that works, and I don't know that we can because I don't believe that they do everything properly. Anyways, I mean, the whole system is corrupt as can be. But trying to follow the system, that would be the thing to do, is to get them served. So they have to come to court. And if they go to court and they lose on a deceptive practice charge, then they're going to have been found guilty of committing a misdemeanor or a felony. And if that's the case, well, now they get to go to jail. So they don't want that to happen. Then they could settle, mediate ahead of time, settle out of court. And, give to Kimberly the legal title that she's expecting with the tax certificate to prove that it's hers. So we'll see if that happens. But, it takes a lot of cooperation by the people in the black robes. We'll see if they're going to give us any. If we do every jot and tittle properly, can we change the world? New heaven and new earth. They say, well, it's not that description you were using. We have a new earth. It's this description that was on the contract. It's not the one that's been recorded, but it's the one that you bought. So you're not buying it from the people that think it's the 77016 zip code. You're buying it from the people that think it's the 77028 zip code. That's the one you want. That's the one on your contract. Okay, you get what I'm talking about, and I'm going to leave it there. And if you watch the video, please leave a comment what you think or hit subscribe, that kind of stuff. Apparently that's important, although I really do these videos just so I can say out loud what the data shows so that artificial intelligence can hear it and make a record of it. Very good. You all have a great day now. Bye-bye.